I just don't think you're a good candidate for probation. I think we try. I'm going to find 13 true. I'm going to revoke, find you guilty, and I'll sentence you under 1244. Does anybody want to state any objection to her being sentenced under 1244? All right, I'll sentence you under 1244.
She had already been given multiple chances through Felony Drug Court, but after new concerns involving her child triggered CPS involvement, Judge Boyd reached her limit. The judge's final message was blunt. Your son is 100% dependent on you. Then came a 2-year state jail sentence.
Call 2020 CR 8599, State of Texas versus Victoria Hernandez. Can I have parties announced for the record? Thank you. For the state. Defense.
Michael DeLeon for Ms. Hernandez.
And are you Ms. Hernandez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And counsel, I know you were recently appointed to represent Ms. Hernandez. Are you waiving your time?
We are waiving any type of preparation period, Your Honor. I believe we have come to a resolution that'll be acceptable to the court.
All right. And do you have any objection to proceeding, Ms. Hernandez?
No, Your Honor.
All right. Are you the same Victoria Irene Hernandez who was placed on deferred adjudication in 2020 CR 8599 for the offense of abandoning a child with intent to return on January 4th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right. State.
Yes, Your Honor. Violating condition number 13 on or about the 23rd day of April 2024 in Bear County, Texas. Defendant Victoria Hernandez did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13.
How do you plead to that? True or not true?
Waiver the remaining violated conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand that?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 13?
I do.
Court will find violation of condition number 13 true. Is there a proposed agreement?
No, there's not.
All right, state, what are you requesting? Defense, what are you requesting?
Your Honor, probation had made a recommendation to extend for 1 year, place Ms. Hernandez in a DDRF, followed by mixed supervision and a parenting class. And as the court could see, she was in felony drug court. DDRF was held in abeyance last time as an option. And she is motivated to go to DDRF, be successful in it. Apparently the wait is only 3 to 6 weeks. And that's what we're asking the court to do.
All right, any objection to the court reviewing the court summary?
No objection, Your Honor.
All right, Ms. Hernandez, I don't think you're a good candidate for probation. And let me just tell you why. Felony drug court is an intensive form of probation. I know that. But from reviewing the court summary, it's not as though felony drug court, you mess up one time or you make a bad choice one time that they say, oh, we're not going to deal with you anymore. And I'm looking here at the sanctions that they gave you over there. And let me just tell you how many sanctions they gave you, which means this is how many chances they gave you. You understand? So it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36. That's what you're coming to this court with. 36 times felony drug court was seeking to work with you. So you see where my mindset is? And do you understand why?
Yes, Your Honor.
And so I placed you on probation here. And even here, you had a motion to revoke filed against you. And that was on, well, it was heard on March 9th, 2022. And that's when you were sent to felony drug court. So I don't think you're a good candidate for probation.
Judge, if I could,
Yes.
one thing for Ms. Hernandez, the good thing about felony drug court for her was that it is our belief that it has worked. She has been clean since September. And if she was tested today, she's going to come up negative.
Mhm.
So, it's not like she totally, yeah, there's several things that she did do correctly in felony drug court. There are a number of things, obviously, as the court has seen, that weren't done correctly, but she's made a lot of her appointments and, she has ended up clean, which is the point of felony drug court.
I just don't think you're a good candidate. I mean, felony drug court, that's a very good program. And what felony drug court has placed, the issues they have with you, I mean, they're major issues, but instead they are still trying to work with you. And they tried to work with you a lot. Here's the thing. I know a lot of people want to stay on probation. They do. Like nobody wants to go to prison. I don't take any joy in sending the people to prison. And everybody that I send to prison or everybody I place on probation, I actually do remember them. Even as a defense attorney, I had some clients who ended up in prison. Guess what? I still remember them and wondering how they're doing and hopefully they've changed their life. And it'll be the same with you. I just don't think you're a good candidate for probation. I think we tried.
And
So,
And Judge, the only other thing is she's never been given a felony conviction before. That's why she wants to stay on defer. She's motivated for it. And that's why she was hoping that the probation's recommendation would be followed.
all right, this is what I'm going to do. I'm going to find 13 true. I'm going to revoke, find you guilty, and I'll sentence you under 1244. Does anybody want to state any objection to her being sentenced under 1244? All right, I'll sentence you under 1244. Let's talk about the time.
Yeah, how much time does she have? Anybody know? How about before the past few weeks?
Yes.
So I was going back and forth with the drug court personnel in this case. And there is some concern if she is given a sentence JSAT.
Oh, it's not going to be JSAT.
Okay.
All right. And what was the concern though? Now you've piqued everyone's interest.
Judge, they feel that a JSAT sentence is not the reason why she was kicked out of drug court and so forth. They just don't think JSAT would be appropriate. And some other concerns in regards to her child. So if she was given JSAT, they just have concerns in regards to that. Now, if she was continued, then that would be something different, but they are not in agreement with anything JSAT.
All right. So what is the issue with the child?
From my understanding, there is a CPS open case for neglect and possible abuse.
Not on me, on the father.
There's an open case.
And state you're asking for revocation?
So we are not opposed to revocation, but we are not with JSAT.
What I can tell you, I wasn't going to give her judgment satisfied. Let me just tell you what my thought processes were.
Yes,
My
Your Honor.
thought process in reading everything was I saw that there's a child involved, right? This case involves a child and it's abandoned with intent to return. And I understand that child, they're telling the report is special needs,
Yes.
but she's making horrible choices.
At the same time, Judge, if she goes to DDRF, it doesn't kick the can down the road. It puts her in a position where potentially she'll be a better citizen, better productive parent. So DDRF only lasts for long, probation only lasts for long. If we help her continue, she has a possibility of one more chance, and the court has given plenty of chances before, but if she's given one more chance, there's a possibility that one day she's going to be still with this child, and that child needs a stable parent, and DDRF will help in that potentially.
Is the state still recommending revocation?
Well, Judge, criminal child involved, I mean, the state would be opposed to the follow-up, and hopefully, because it looks like the person knows that we have in our system, that the defendant might have an anger problem, and any type of additional help might help for the future of that child at least.
Well, I will tell you what, your special needs child has saved you, and you are not saving your special needs child. So where is the child now?
He is with his father at the moment. The CPS case is on the father and the current girlfriend. And
So let me get this straight and correct me if I'm wrong. So you are saying that there's allegations of abuse and those allegations are abuse against the father who he's with?
Yes, Your Honor. And the case has been open for about they opened one CPS case, my court did, because of the what they had found in my phone. And then the caseworker got in touch with
What did
with
they
the
find?
father.
Wait, raise your right hand for me, please. You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth.
Yes, Your
So
Honor.
help you God.
Yes, Your Honor.
All right,
So
state your name.
Victoria Hernandez.
What did they find in your phone?
So they found that, so I had found out that my kid's father was locking my son in the room, and I wasn't aware. So later on, they said that it was because the autism doctor recommended that they lock the door at night. But I thought like they were just locking my son in the room like all day. And so that's what drug court found on my phone when they were going through our messages, was me like getting mad at the dad about locking my son in the room, and so they called CPS for neglect. And then the dad got another CPS case because I believe the school called CPS for neglect as well.
All right, any objection to somebody from drug court zooming in? All right, just have a seat. Drug court is going to zoom in so we can get to the bottom of what's going on. All right, Norma, who do we have left on the docket? All right, let me call Mr. Church's fine up. All right, did you confer with the state about?
We did, Judge. I conferred a while ago, Your Honor.
Good afternoon. Are they in agreement to your motion?
They weren't at the time.
Court is calling NIMAG number 743637, State of Texas versus Joseph Smith. Can I have parties announced for the record for the state?
Jason Garrett.
Defense?
Gary Church for the defense.
And are you Mr. Smith?
Yes, ma'am, I am.
All right, there's a motion to modify bond restrictions. The defense is asking that GPS be removed. Is that correct?
That is the start, yes, Your Honor.
Judge, we're opposed. This is evergreen, so we're unagreed with the total removal of GPS.
All right, so with the motion to remove GPS is going to be denied. And here it states that
Judge,
he's in.
do I have a chance to reply?
Sure.
This is a self-defense issue. He has not been found guilty. This is a decorated veteran, 3 Purple Hearts, the Bronze Star. He felt that it was lethal. No shots were fired. The guy who is alleged, the complaining witness, is running around without a shirt in December, stone on his butt, causing problems. He approaches my client. My client shows his gun.
As it goes.
The guy comes after.
Okay,
him.
let me ask you all this. Counsel,
Yes, ma'am.
did you view this?
Yes.
It's on video, ma'am.
Okay, so this is where we are.
He was telling my son he was gonna kill him because he was white.
Well, stop. So this is where we are is I have that there's another judge who puts you on GPS for aggravated assault with a deadly weapon. Another judge, stop. So that's what you're on for. Now, what I'm saying is I'm not removing the GPS. So the next question is, you say in your motion that he's fully employed, correct?
Judge, he is 100% disabled. He was working with the National Guard and DPS down at the border. But since the arrest, he has not been able to assist them. He was teaching marksmanship, I believe is what you were doing.
So I'm a trained scout sniper for the United States.
All right, I don't think,
I was teaching them weapons and pistol techniques.
all right, so I don't believe with the nature of your charge, they will allow you to continue.
No, ma'am, that's why I had to lock up my ranch and stop. I had no, that employment is not coming in. It's just my wife and I'm barely making it.
Judge, may I interrupt?
Sure.
He is a veteran who diagnosed with PTSD and other issues. I had a client. There's been issues where he's actually called pretrial and in a suicidal mood. Okay. I had a client, same situation with him. They GPS'd him. He committed suicide.
Okay, let me stop everybody right there. Do not put it on this court that somebody's going to commit suicide because they're on GPS. What before me, sir? What I have before me is that they're charging you with aggravated assault with a deadly weapon. If somebody wants to file a motion for an examining trial and call witnesses, they can do that. If somebody wants to call in a witness for this hearing, you all can do that. But right now, both sides are just giving me argument. And what I'm telling you, sir, and what I'm telling your counsel is another judge placed you on GPS for an aggravated assault with a deadly weapon.
He done
I
that.
don't have any information.
Yes, ma'am. He done that because I live so far away. I live in Eagle Pass, Texas. And that's why he done that.
All right, so here's my question, State.
My
Yeah.
mental health is suffering. I haven't had a chance to see my doctors. My physical health is suffering.
Mhm.
I'm going to remission right now of stomach cancer.
Okay.
my own home to become my prison.
Okay, so I don't think anybody's listening to what I'm saying because everybody is entrenched in what their arguments are. So the first question I was asking you, because in your motion, it says defendant is gainfully employed. So what I was going to, well, I know you're shaking your head no, but that's what your counsel put in the motion. Defendant is gainfully employed. That's why, time out, listen. That is why I was asking, are you employed?
Yes, Your Honor.
Because I'm sure the state is not going to have any objection to you working. You're going to remain on GPS. Now, the next question, you're saying that you have doctor's appointments you need to make.
Yes, ma'am.
State, are you going to have any objections to him being allowed to go to his doctor's appointment? So he'll be on partial for his doctor's appointments. He'll be able to go to his doctor's appointments.
I can't go to church. I missed my father's funeral. My son's coming in a week. I haven't seen him in over a year and a half. He's a Marine also. I'm
Mhm.
not gonna be able to see him. Your Honor, this is a detriment to my health.
Judge,
The only reason I used my weapon was to escalate the force. I know how to escalate the force. I'm a Marine. I didn't use, I pointed it at him.
Judge, I'm just gonna object at this point. I think they're going with the facts of the case.
They are. And this is what I keep telling everybody. This is what I want everyone. Take a moment, decompress. This is what I'm telling everyone.
Thank you.
One, you're telling me he's a veteran. He has a Purple Heart. This is what happened. All of my male relatives have been in the military. All right. So your service is appreciated.
For service.
But let me just tell you what my job is as a judge. Part of my job is one, to protect the community,
Yes, ma'am.
right? There are a lot of people who are on bond right now. They're on bond for murder. Some of them have GPS, some of them don't have GPS because whoever read them their rights and let them know their conditions didn't give it to them, right? So the person who placed you on GPS, they read a report. Either you were arrested at the scene and you were brought in before a magistrate, and that magistrate judge decided that you were going to be on GPS. Then,
I was brought in front of a magistrate and
Yeah.
I paid $100,000 bond to get out.
okay,
And I exercised extreme discipline and prejudice when how hot.
Mhm.
When there is a
Mhm.
not just to me, but to my family member.
All right, we can go off the record. Let me ask you something.
ma'am.
All right, so you're telling me all of this. What do you want me to do?
Ma'am, I'm not going anywhere.
No. Listen to me. My question is, what do you want
I
me to
want to
do?
be able to take my son fishing before I die.
Okay, so you want to take your son fishing. What day you want to take your son fishing?
Whenever I'd like to.
No, you need to give me
I
when.
can't work on my ranch anymore with the Army National Guard or the DPS because it had to do with weapons.
Okay, so there you go. So,
I don't have
so we
that.
know that's off the table. So my question to you is, you want to go fishing with your son? What else do you want to do? Okay,
can we consider tracking?
all right, you need to talk to the state about that. All right, step back. Y'all confer. No problem. All right, we're back on Victoria Hernandez. Hi, Officer Garcia.
Hi, Judge. How you doing today?
All right, how are you doing?
I'm great.
I miss you guys.
We miss you too.
Okay. All right, Miss Hernandez, if you'll come down, and Mr. Garhan, I'll let you all continue to talk, but this is Miss Garcia, so she's going to give us information. All right. We're back on the record in 2020 CR 8599, State versus Victoria Hernandez. All right, so we have Officer Garcia by Zoom. Any objections to her being by Zoom? Defense?
No objection, Your
All
Honor.
right, and the state has already stated that they do not have any objections. Officer Garcia, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Do you waive any confidentiality that Ms. Garcia has as it relates to your time in felony drug court? All right, so you're giving up that right.
Yes, Your Honor.
All right. Any objection to her testifying in the narrative?
No, Your Honor.
All right, Officer Garcia, what we're trying to discover is whether or not she should be revoked or whether or not I should send her to DDRF. What has transpired is there's been a mention of a child with special needs because I was inclined to sentence her to the Bexar County Jail under 1244 to 1 year. Can you tell us how she was doing? What have been the issues with her in the drug court, and what would be your recommendation for her?
Victoria was on my caseload the entire time that she was in felony drug court. As you saw in the court summary, we did work with her extensively. Every time there was a violation, we used progressive sanctions. We did have DDRF in abeyance back on 9/20/2023. Instead of that, we went ahead and gave her the chance to do Alpha Home, which she did complete. However, she went right back to her old criminal thinking. People, places, the basics that we teach in felony drug court. We were working with her and we happened to do a phone search only because there was another phone search done on another participant, kind of intertwined the two. And that is the only reason why we found out is like it fell into our lap. It wasn't something that we were looking for. And we had concerns again, because of her special needs child. We do have another case against her in CPS. So the CPS case, there is one pending for the father of her child, and we do also have one for herself.
All right. Do you know, with regards to the case for herself, what is that about?
Because of what was found on her phone.
So what was found on her phone has absolutely nothing to do with the child's biological father?
It's actually both of them are involved. But again, he was the only one that the case had, the first CPS case is only on him. So when we found the information that included both of them, a CPS case was filed against her as well.
So what was on her phone? Did it have to do with, I don't want to get into too much, but what was on her phone? Did it have to do with her as it relates to her and her child?
Yes, concerning for her to be around her child, absolutely. And then considering her case that she's on as well. So with that being said, we have seen often that we work with the individuals and there wasn't really enough progress and we don't feel comfortable with, one, probation doesn't like to recommend revocation, but we have seen in drug court that a lot of our participants are getting credit for time served. So we didn't want her to just get a JSAT and be done, because then there's no problems that are fixed. And then we have the concern for the son, because she will be able to go back and just be around him. That was what she was trying to do while she was on my caseload. So that is very concerning. If I could recommend revocation without the JSAT, and I would like to, that's what I would like to happen.
All right. Do you have any questions?
I do, Judge.
All right.
Officer Garcia,
Yes, sir.
throughout her time throughout felony drug court, she tested negative on multiple occasions, correct?
She did, however, she also tested positive.
How long ago was that?
Let me check. Drug test. Well, she did have a no-show, so to us, that was April the 17th. That is considered a positive in felony drug court. Let's see, her last positive would have been September of last year.
2023?
Yes. And again, she did go to treatment during that time frame before we just got her back reporting in person.
That's all I have for you. Thank you.
And Officer Garcia, you all are not willing to accept her back. Is that correct?
No, Judge. We've worked so much with Miss Victoria, and it just seems like we hit a wall at this point.
All right. Thank you so much for zooming in on such short notice. I appreciate it.
Yes, Judge, you have a good rest of your afternoon.
Okay. All right. Bye-bye.
Bye-bye.
All right. So with her, it's going to be revocation. Are you still insisting that what was in your phone was not related to you?
I wasn't aware the second time around that a CPS case was put on me. I've been in jail.
No. My question is, are you
is.
still saying that what was on your phone regarding your child is unrelated to you?
No.
Okay.
Judge, in lieu of that, we're asking for the minimum time allowed. Apparently she has 158 days in custody over the past 3 or 4 years. And I would argue that, she has done several things right. She's also done several things wrong, but there was several things. She did participate in the felony drug program and did a lot of good things. So we want the court to reflect on that.
All right. This is what the court is going to do. Court is going to revoke you. Let me see, where is the trial court certification?
Did it to the court.
I do have it here. The court is going to revoke you. The court is going to find you guilty. The court will give you credit for any time served. The court will give you credit if you successfully completed inpatient treatment, because I see there was some inpatient treatment maybe through alcohol. If you successfully completed that, the court will give you credit for that. And the court is going to sentence you to 2 years in the state jail facility. I'll recommend the therapeutic community. I can't force them to place you in there, but if you request it, they will consider it. If you don't request it, they will not consider it at all. And I'll also request mental health while she's at the state jail facility. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're going to have to get your life in order. If you don't, your life is going to continue to spiral out of control. Felony Drug Court is a good program. They work with you for 2 years trying to help you, and you still just want to do whatever you've been doing, which is not good for your son. I always tell people you're an adult. Your son is not an adult. Your son is 100% dependent on you, upon you, and you're just doing foolish things. Good luck to you. All right. Are we ready on Joseph Smith? All right. Thank you. Yes. And Mr. DeLeon, could you hang around for just one moment?
Yes, Judge.
Yes, sure.
I think you got the violation report from him. He's
I don't have the, okay.
yeah, but he's asked me to come and ask if the court would consider setting a bond in anticipation of him surrendering.
No, tell him he needs to turn himself in before the court will issue a bond.
As my last representation of him, we talked about my withdrawing. Would you at least allow me to file a motion to set bonds so it'll be in place
Yes.
so that when other counsel gets appointed?
Well, when he turns himself in,
Yes, ma'am.
then the court can hear your motion to withdraw, and the court will hear the bond issue with a new attorney if the court allows you to withdraw.
Thank you.
All right, thank you. All right, just give me one moment. Could you mute us for a moment, please? All right, so we're back on the record, and NIMAC number 7433637. Is there any agreement?
I guess no, right, at this point right now, Judge, the judge, the state with the position is we're okay with partial for like work, for doctor's visits, and anything that the judge wants to allow them to partake in with family members. The state would not be opposed to any of that at this particular point. And I've talked to the defense counsel about it. I've had my investigator run some things, and there's just some stuff that the state is concerned about. However,
All right.
understanding.
Do you have any objections to medical appointments and no objections for work? All right,
Judge, I won't be objecting to the attend church service on Sundays.
all right, this is what we're going to do. It's going to be agreed order. Well, this is what the state is in agreement to. So there'll be partial GPS for work and medical appointments only. Is there anything else?
Just if I have a father, I have 2 young sons. If they should arrive for take my son to work or pick him up, or God forbid he be in a car accident, he skateboards a lot, I've taken him to ER, I don't know how many times.
You need to call your pretrial services officer and let them know that it's been a medical emergency.
I tried calling them on the day my father passed away, and I called him 13 times.
All right, so what you'll need to do is leave a message with them. If they don't respond, you let your attorney know. I'm usually here.
Thank you, Judge.
No, here's the thing. There's no need to apologize. I understand that all of these cases are here for everybody. That's why I always tell everybody, if we're here for a length of time, or if I spend 20 minutes on a case, I will tell you, some attorneys get upset. Hey, I need to be somewhere else. You're spending 20 minutes on this case. But here's what I know. What I know is that every case that's in this court is very important to the person who's charged. So if I take extra time with that person, guess what? I want them to be heard. And I know that their case is 100% important to them. So it's important to me. All right. So apology accepted.
Your Honor,
You're welcome.
I want you to know that I did
All right. Thank you so much. All right.
a better day than what you've had.
Oh, no, my day has been great.
They had a scratch on your face from your car.
Oh, yeah. But you know what? It's going to be fine. All right. Thank you so much. All right, so we'll be back on Monday. No, not Monday. We'll be back on Tuesday. I keep saying Monday is Memorial Day.
Yeah.
And so we need to celebrate it other than just cooking our ribs and everything that we do and remember what the day is really about, which is about.
Victoria Hernandez's hearing ultimately came down to a difficult question. How many opportunities can a court provide when rehabilitation efforts continue to fail? The court had already used progressive sanctions and provided access to felony drug court and treatment. But after new concerns involving Hernandez's child and testimony that the program had reached its limit, Judge Boyd decided that continued supervision was no longer appropriate. The judge's final message focused on something bigger than punishment. She reminded Hernandez that her son is dependent on her and that the choices she makes as an adult can directly affect the people who rely on her. The court ultimately revoked her supervision and imposed 2 years in state jail, while still recommending treatment and mental health services. Subscribe to follow this case and see whether Victoria Hernandez uses the treatment opportunities recommended by the court to rebuild her life and eventually regain the trust needed to be there for her son.